Hello, I'm attorney Dan Marr from the Nashua law firm of Hamblett Kerrigan here in New Hampshire. I've been practicing law for approximately 36 years in New Hampshire and about 28 years in Massachusetts. So I practice in both states, both the state of New Hampshire and the Commonwealth of Massachusetts. And I wanted to discuss today about negotiating business deals. This is different than when I'm dealing with litigation. I may be negotiating a resolution of a lawsuit and the parties are not going to see each other again, so you're negotiating the best possible deal that you can get in the situation, and then you are leaving, the parties are leaving each other, and that's the way it is. But in business transactions, you're going to have a relationship, and I'm going to talk about some of those issues. About you can learn a lot in the negotiation as to the other side, and then also whether you want to have a relationship with the other side, but then also some of the negotiating tactics. I'm going to talk about those in general. I've dealt with a lot of situations with everything from commercial leases to shareholder agreements, operating agreements for limited liability companies, vendor agreements, master service agreements, which is called something that's called a general contract with a group, and then you often will have statements of work that will deal with particular deals. All of those things I've dealt with, but I'm going to be just talking about some general concepts in this vlog about negotiating. One of the first concepts that I want to talk about is the notion of, well, this is standard in the contracts. Somebody will say often in a situation, this is what we have in, we always do this in our contracts, or this is standard in the area of this topic that we're dealing with. Maybe it's dealing with a lease, maybe it's dealing with a particular industry that you're talking about, and the other side saying, this is standard. So what? It doesn't matter to you whether or not something is standard. When I have clients that go and say, let me know if these provisions are standard, that's only if they're acceptable to you. If they're not acceptable to you, don't do the deal. There are certain things that may be standard in the industry for some people, and it's not worth doing. By way of example, there's sometimes limitations of liability provisions that somebody will get from another side, and maybe they'll do that when they're dealing with somebody that has a very shallow pocket, meaning they're insolvent if the deal falls apart anyway, so they don't have much to risk, or they're in a jurisdiction outside of New Hampshire that's very difficult to get the assets of. So all of those things factor in. So just because somebody says that's standard, for one, doesn't mean that those other people are doing the right thing. They may not be. They're negotiating these contracts, but it doesn't mean that it makes sense for you. And I'm strongly recommending that you don't follow the path of what is standard in a provision. Look at the agreement, look at how it's going to affect you, and make decisions on it. Now, of course, in any negotiating, leverage matters. So what power you have versus what the other side has matters a lot. But these concepts of, there's a very good negotiating book. There's a Harvard management team negotiating book, and there's another book out, negotiating book, both that's called Getting to Yes. Both of them are excellent books. But the Getting to Yes one doesn't mean that you should always get to yes. In the book, it doesn't say that you should always get to yes. Sometimes the best deal you can have is getting out, is saying, no, I'm not going to do a deal. And what I really look at when I'm dealing with negotiating on something long term is, how do they negotiate with you? You do want to work a deal out, generally you do, but you don't want to cave on something that's going to hurt you. And sometimes saying no is the best business decision you can have. And look at the negotiating strategy of this person. I've told clients before, several clients before, dealing with some people that are dealing with a negotiation, if they're a really tough negotiator, meaning mean-spirited, and they're just hankering down and saying, no, we're not going to do anything other than this, and you better take this or else, that's kind of like an abusive significant other of yours. They're verbally abusive or physically abusive, and they're saying everything's going to get better when we get married. Don't do it. Don't get into that relationship. If they're treating you that way right there, you want to figure out that, and you talk to your attorney about it and decide about what a long-term relationship with this other business is going to be. You might be excited about the possibility of some income, but if they're saying things like they're refusing to have a provision as to late payments, or some other, if you want to limit your damages and are refusing to do that, there's a warranty issue that you're discussing that you just don't find it broadening your warranty is worth it. Think carefully about those, and maybe you might make the decision that the best answer is to say no. So I'm Dan Marr, Hamblett Kerrigan. I negotiate a lot of these contracts, and yes, we get to yes the vast majority of the time, but sometimes there's situations when you really look at the circumstance, and for your business future, you want to really think about whether or not you want to get into that deal. And just because the other side says these are standard in the industry, that's not controlling. It's what makes the best sense for you as to whether or not this deal is going to be effective to you or it's going to be an albatross around your neck. So happy to talk to you. 603-883-5501. Again, our telephone number is 603-883-5501, or check out our website, NashuaLaw, all one word, .com. That's NashuaLaw.com. I have weekly vlogs in there of a variety of topics, and you can review those, and you can contact me as well through the telephone number. Look forward to working with you if the opportunity arises.